cases on PRSA rights. Brotherhood of Trainmen v. Virginia E. Exerell, Virginia State Bar, 377 U.S. 1, v. Wainwright, 372 U.S. 335, Argesinger v. Hamlin, Sheriff 407 U.S. 425. Litigants can be assisted by unlicensed laymen during judicial proceedings. Conley v. Gibson, 355 U.S. 41 at 48, 1957. Following the simple guide of Rule 8, F, that all pleadings shall be so construed as to do substantial justice. The federal rules reject the approach that pleading is a game of skill in which one misstep by counsel may be decisive to the outcome, and accept the principle that the purpose of pleading is to facilitate a proper decision on the merits. The court also cited Rule 8 FFRCP, which holds that all pleadings shall be construed to do substantial justice. Davis v. Wechsler, 263 U.S. 22, 24, Stromberg v. California, 283 U.S. 359, NAACP v. Alabama, 375 U.S. 449. The assertion of federal rights, when plainly and reasonably made, are not to be defeated under the name of local practice. Elmore v. McClellan, 1986, 640 F. Sup. 905. The right to file a lawsuit pro se is one of the most important rights under the Constitution and laws. Federal Rules of Civil Procedures, Rule 17, 28 use a next friend. A next friend is a person who represents someone who is unable to tend to his or her own interest. Haynes v. Kerner, 404 U.S. 519, 1972. Allegations such as those asserted by petitioner, however inartfully pleaded, are sufficient, which we hold to less stringent standards than formal pleadings drafted by lawyers. Jenkins v. McIdern, 395 U.S. 411, 421, 1959. Picking v. Pennsylvania Arco, 151 Fed 2nd 240. Puckett v. Cox, 456 2nd 233. Pro se pleadings are to be considered without regard to technicality. Pro se litigants' pleadings are not to be held to the same high standards of perfection as lawyers. Matty v. Grassley Chemical Co., 303 U.S. 197, 1938. Pleadings are intended to serve as a means of arriving at fair and just settlements of controversies between litigants. They should not raise barriers which prevent the achievement of that end. Proper pleading is important, but its importance consists in its effectiveness as a means to accomplish the end of a just judgment. On WECP v. Button, 371 U.S. 415, United Mine Workers of America v. Gibbs, 383 U.S. 715, and Johnson v. Avery, 89 South Court 747, 1969. Members of groups who are competent non-lawyers can assist other members of the group achieve the goals of the group in court without being charged with unauthorized practice of law. Picking v. Pennsylvania Railway, 151 F.2d. 240, Third Circuit Court of Appeals. The plaintiff's civil rights pleading was 150 pages and described by a federal judge as inept. Nevertheless, it was held where a plaintiff pleads pro se in a suit for protection of civil rights, the court should endeavor to construe plaintiff's pleadings without regard to technicalities. Puckett v. Cox, 456 F. 2d 233, 1972, 6th Sir. Uska. It was held that a pro se complaint requires a less stringent reading than one drafted by a lawyer per Justice Black in Conley v. Gibson, see case listed above, Pro se rights section. Roadway Express v. Pipe, 447 U.S. 752 at 757, 1982. Due to sloth, inattention or desire to seize tactical advantage, lawyers have long engaged in dilatory practices. The glacial pace of much litigation breeds frustration with the federal courts and ultimately, disrespect for the law. Schreier v. Cullen, 481 F. 2d 946, 1973. There can be no sanction or penalty imposed upon one because of his exercise of constitutional rights. Schwer v. Board of Examiners, United States Reports 353 U.S. pages 238, 239. The practice of law cannot be licensed by any state. Sims v. Ahern, 271 SW 720, 1925. B. Platsky v. CIA, 953 F.2D25, 2628, Second Sir. 1991. Courtors if court dismisses pro se litigant without instruction of how pleadings are deficient and how to repair pleadings.